Heavenly Father, today we put on the full armor to protect us against attack. We put on the belt of truth to protect against lies and deception. We put on the breastplate of righteousness to protect our hearts from the temptations. We put the gospel of peace on our feet to walk in your light, peace, and freedom with the Holy Spirit. We rebuke anxious thoughts. We take up your shield of faith for protection to block and destroy all the darts and threats thrown at us by the enemy. We put on the helmet of salvation to cover our minds and thoughts, reminding us that we are children of a mighty King. We are forgiven, set free, saved by the blood of Jesus. We take up the sword of the Spirit, your living word, that has the power to demolish strongholds and is sharper than any double-edged sword. We come to you, Lord, in prayer daily. In Jesus' mighty name we pray. Amen.
Amen.
What's up, you guys? Welcome to The Imagination. I'm your host, Emma, and today I'm honored to introduce you all to judicial corruption and court reform victim and advocate, writer and author, content creator, retired teacher, basketball coach, and a man who is single-handedly and successfully taking on the court system, Brian Vukadinovich. I met Brian recently on Twitter, and when I saw his body of work and what he was advocating for, I knew we had to bring him on the podcast to corroborate what countless guests have shared about the court system being corrupt, as well as functioning as a child trafficking racket. Like many advocates, Brian's passion for bringing awareness to the corruption within the court system began with a personal experience gone wrong and the integrity to want to make it right. Brian is a retired teacher and basketball coach in Indiana and has served as executive director of the Posner Center of Justice for pro ses based in Chicago, Illinois, for retired federal court of appeals Judge Richard A. Posner. He has successfully represented himself in state and federal court proceedings in Indiana, including winning a federal jury verdict against his former public school corporation employer in Indiana in March 2016 for violating his due process rights in a 5-day trial where he represented himself against the corporation's team of lawyers. He has received national acclaim for his self-representation ability. According to Speakerpedia, Brian is considered to be the leading pro se litigant in the country, as he is believed to be the only person to have ever won a federal civil rights jury trial by representing himself without a lawyer. According to Speakerpedia, Brian is considered to be the foremost expert in the country in the art of pro se litigation, the ability to represent oneself, and he has spoken on the topic in several different forums and interviews, including speaking to a Yale Law School class about how he was able to successfully represent himself and win the federal civil rights jury trial against his former public school corporation employer. Brian's testimony and the information he will be sharing is vitally important because, as we've heard many times on this podcast, court proceedings can go terribly wrong when an optimistic and innocent person or parent blindly allows the court system and their lawyers to take charge of their case. In a world where TV and movies naively bring us to believe that the court system exists to bring justice for all, the truth is that nothing could be further from the truth. What this podcast has not only discovered, but proven through the power of corroborating testimony, is that the court system is a business first and foremost that makes its money off innocent adults and children who become a commodity as soon as they walk into the courtroom. From trafficking children to abusive parents to wrongfully accusing the innocent of being guilty, the court actually exists to generate money off the highest bidder. And the highest bidder is typically the parent or person who is willing to go broke fighting for what is right and who naively takes the bait of believing they will achieve so-called justice if they just give one more dollar to the cause. Brian has written 2 highly acclaimed books on this topic, Motion for Justice, I Rest My Case, and Rogues in Black Robes, after he discovered from personal experience how corrupted the court is, as well as having success in getting around the red tape of lawyers and judges by representing himself. We all have so much to learn from Brian and his heroic story of never giving up and never giving in. And I pray you all on the other side of the screen currently are facing, who may be in the future facing circumstances, end up getting hope as well. These incidents can happen to anyone, and our greatest weapon against this darkness is to empower ourselves with knowledge on how the court system operates, as well as what to be aware of before we even step foot inside. I ask that you all give Brian your full attention as we are all going to learn so much value today from a man determined to expose the rogues in black robes for who and what they are so that we can come together and reclaim innocence in both sentencing and with our precious children. Before I finish introducing today's guest, I wanted to give just a couple reminders and updates. If you'd like to be on the podcast as a guest or share any information privately with me, you can email me at imagineabetterworld2020@gmail.com. You can also use this email if you'd like to be a part of my new book series featuring written survivor testimonies, and you can find the video with all the details on how to submit your testimony on any of my podcast channels. And lastly, I'd love your support on Substack, where I've taken up investigative journalism as an outlet for me to share about the podcast, guests, and advocacy work, and you can subscribe to me there at www.emmacatherine.substack.com. All my links are in the show notes, and I'd love your support across all platforms. Thank you all for caring so deeply about survivors and whistleblowers and for helping to make the Imagination podcast the safest space on the internet for survivor and whistleblower disclosures. So you guys, without further ado, please help me in welcoming today's guest of honor, voice for the voiceless, selfless servant and survivor and victim advocate, passionate pursuer of truth, and a man who will be remembered as one of the most successful pro se litigants in modern history, the one, the only, Brian Vukadinovich. Brian, thank you so much for being here with me today.
Thank you, Emma, for inviting me. It's a privilege and an honor for me to be here on here with you. And I've watched several of your podcasts that you've done, and I have to say you're doing a great job. I'm out there trying to educate the public as much as I can from my end, and I can't do it by myself for sure. And then when I saw the things that you're doing, I was so elated when you asked me to come on and do what we're going to do here tonight, and maybe some more in the future. And just I have to tell you, just the name, the Imagination podcast caught my attention right off the bat, just when I saw that title, because it's very strong. It's a very forceful title, and you're a very forceful host and a very strong host. And it's just a pleasure and an honor for me to be on here with you as well. I just, there's just, and by the way, thank you so much for that really nice introduction. Thank you. That was very nice of you to say that like you did. Hopefully I can measure up to the people's expectations here, because I know you have a great audience, you have a great following, and we're going to talk about some important things here tonight, you and I. So what I'll do is I'll talk about things that I've experienced in my lifetime in the court system, and I know you specialize in the family court system with things that you're doing, and as of late, I've been doing quite a bit of research on the family court system myself, and I just the things that I'm seeing going on in the family. In fact, I believe it was in Pennsylvania, if I'm not mistaken. Just a few years ago, they had this situation going on where they built a facility. It was a juvenile center of some kind, and this particular judge, it was called Cash for Kids. It received a lot of notoriety, and what was happening was it was a family court situation, and it was basically a juvenile court, and this judge somehow got involved with these people that built this facility, and then of course they wanted to house the facility. They wanted all the cells to be full of people, so they made a deal with this judge. If you can fill our cells in our facility with the juveniles that come through your court, you'll get a kickback for each one. So there was an investigation made, and I believe the name of it was Cash for Kids. If you just type that in, you'll probably come up with it. And this judge, he was getting thousands and thousands of dollars. I mean, kids are kids. They'll do some stupid things sometimes, like I believe one of them spit his gum out. I think one of them, he spit his gum out on the sidewalk, and he got arrested, and they made a big deal out of it. And they actually sent him to that center for I don't know how long, but that judge was paid a kickback for that type of thing, just a minor thing. So in other words, we have a problem in our country with judges taking kickbacks. I believe, in my opinion, I believe it's going on all over the place in the state, federal court systems. It's very hard probably for people to believe that, because people generally don't want to believe that the courts are corrupt. People want to trust that the courts are on the up and up, but they're not. I'm sorry to say they're not. These judges, and I call my book Rogues in Black Robes. They're just lawyers. And then when they walk into the courtroom, they expect people have to stand up and give reverence to them, and as if they're like a god of some kind. They're simply put, they're just lawyers. They're politically connected lawyers. They had enough political clout, either state or federal, because that's what it takes to become a judge. You have to have a lot of politics behind you. They're just lawyers. They put on a black robe, and all of a sudden it's like, oh, this is a god. They're not. They're not. And I know back in the early '80s, there was a sting operation in Cook County, Illinois. It was basically in Chicago, Cook County, Chicago, basically. And the word was getting out that judges were fixing cases left and right for money. And just the word got out, and then lo and behold, the feds actually decided to investigate. So then they did a sting operation, and they placed certain people into the various courts in Cook County, and they were moles. They went in there. They had devices on them. They were recording the judges and so forth. And the judges didn't know it. So they were actually recording judges while they were taking kickbacks. Like, for example, a DUI case, a drunk driving case. The lawyer would, the client would, okay, he got arrested for being drunk while he's driving. He would come into court. The lawyer represents him, got a bad case going on against him. He, for example, okay, it's going to cost you $10,000 for me to represent you, but I'll get you off. Okay. He takes the $10,000. He passes $5,000 to the judge. The judge hears the case, and the judge makes a determination that he should, walk away scot-free. He dismisses the cases against him. So this is what was going on in Cook County in Operation Greylord. There's actually a book about it. If people are interested, they can just type in Operation Greylord, and they'll see that book, and they'll see some writings about it. But the point is, if that was going on in the early 1980s, and we know it was going on because it's a recorded fact that it was going on, what's to say that that's still not going on today? Why has there not, I know I haven't seen any sting operations in courts around the country that happened there. Well, why not? Did all of a sudden, from that point on, all of the judges all of a sudden got completely clean and saw the light? I'm sorry, no. It's just a situation where, and people that are watching us here right now, they know what I'm talking about, because there's a whole lot of people in the country, your audience included for sure, that are getting a shaft job in the courts. And sometimes when you look at all the facts in a case, and even the law, and believe it or not, sometimes the non-lawyers actually even understand the law as well. It doesn't have to be just lawyers. I mean, if you can read law and you can understand it. And then you have a case, and then the judge goes completely against you, and you say to yourself, how could that be? I have all the facts on my side. I have the law on my side. Why did I lose this case? Why did this judge rule in favor of the other side? And it leaves a bitter taste in your mouth when you walk out of a courtroom like that. And I'm going to strongly suggest, not all cases, but in a lot of cases, there's kickbacks involved. And I'm sorry, I just one way we could eliminate that problem is, years ago, their employers employers wanted to start doing polygraph tests against their employees, lie detector tests. And there was a big argument. It actually went to the U.S. Supreme Court about whether or not polygraph tests, lie detector tests, would be an invasion of a person's privacy rights. Should the corporation be able to do that? So that issue went to the Supreme Court, and the Supreme Court ruled that the corporations have a right to do it. If you're not willing to agree to a polygraph test, then the corporation has a right to terminate you as part of the condition of employment. So that's what the Supreme Court said. The reason I'm bringing that up is this. Well, if the Supreme Court thought that it would be valid for an employer to require a polygraph test of its employees, then why shouldn't there be a polygraph test requirement for judges as well? Like a yearly polygraph test. Every year, every state judge and federal judge has to take a yearly polygraph test. And it doesn't have to be, 100 questions, just a few questions. For example, a question that I would ask if I was asking questions to a judge, I would ask, have you ever had any ex parte conversations? Ex parte meaning conversations with a certain party, with a certain side in the case, but the other side isn't involved in the conversation. In other words, a secret conversation. That, if you're the plaintiff and the judge is having conversations with the lawyer or with the lawyer's client, and you don't know about it, that's inappropriate. That's an ex parte conversation that is forbidden. But how do we know they're not doing that? How do we know that there's not judges that are meeting with lawyers and cutting deals for kickbacks? So my point is this. We wouldn't have that problem if the judges had to take a yearly polygraph test, and that was one of the questions. Have you ever met in private, in secret, ex parte, with either side in a case and discussed the case, which you're not supposed to do? So that would be a question that should be asked. It would be real. See, if they knew they were going to have to answer that, they couldn't do it because it would show up on the polygraph test. And another question I would ask, I would go along with it, and I would just say, have you ever accepted cash, any money, any benefit, a vacation? We've been hearing all this stuff about Clarence Thomas and so forth, about all the vacations, and I don't get into the politics per se of the stuff, but he is a Supreme Court justice, and he's been getting these vacations, paid by, through people involved with cases, and it looks bad. It looks bad. So have you ever received any cash, any money from a client on either side of a case? Yes or no? Okay. If they know they were asked that, they couldn't do it. We may not have half the judges that we have now because they would all be disqualified, but we'd have a clean judiciary if we did that. So my point is this. If the U.S. Supreme Court feels like it's okay for employers to do that against the citizens, against the people of the country, then why shouldn't the judges also be subjected to that type of an exam every year, just so we know that they're clean, that they're on the up and up? That's the only way we're ever going to see. There's too much. We trust too much. Oh, they have their judicial canons. They're supposed to act right and correctly, and all of this and all of that. That's not worth the paper that it's printed on. They're violating so many rules and canons. It's going on in my case right now as we speak. I'll talk about that here in a minute. I'll talk about it here in a minute. I have a lawsuit pending in federal court right now against that former judge, Richard Posner, who hired me to be the executive director of the Posner Center, and now he doesn't want to pay for my services. So I filed a breach of contract case against him. It's in federal court. And the lawyer in that case, his name is Justin M. Ellis. He's in New York. Now, Posner's got several lawyers. He's got lawyers in New York, Chicago, and Indiana. He's got several of them battling me, and I'm pro se. And this one particular lawyer, his name is Justin Ellis. Yeah, that's him right there. He's representing Posner. He's basically the lead lawyer. And on March 8th, just not too long ago, he wrote a letter. He wrote a letter to the magistrate judge. The magistrate judge's name is John E. Martin. John E. Martin. And on March 8th, he wrote a letter to the magistrate, Judge Martin, and he asked, this is point blank, he asked the magistrate judge, these are his words, for assistance, quote, assistance to, quote, help him bring the case, quote, to a swift end. Those are Ellis's words to the judge in the case. Judges have no business whatsoever helping lawyers on one side of a case or the other to help them and assist them in bringing a case to an end. And that's exactly what Ellis asked this judge to do, this Judge Martin, John E. Martin, a federal magistrate judge. John E. Martin was asked by the defendant's lawyer, by Posner's lawyer, to help and provide assistance to get the case put to a swift end. And that is totally inappropriate. Now, I have addressed that in court. And now this Judge Martin, he has not denied that. And he's had plenty of opportunities, because I've addressed this in court filings, how inappropriate that was for, just the fact that Ellis felt comfortable enough that he could write a letter like that to the judge alone is cause for alarm. Just the fact that he felt like, hey, I can write a letter to this judge and I don't think I'm going to get in any trouble with this judge, and I'll just ask him point blank, help us, provide assistance to us to put this case to a swift end. And that's the type of things that are going on in the case that's going on right now that I'm handling. So we'll see what happens. There are court papers filed on it. I very strongly address that in court filings. Now, there is so people understand, in federal court, if anybody from your audience is involved in a federal court case, it's a little bit different than state court. In federal court, there's a rule that, now there's a judge that's assigned to the case, a regular district court judge, and then by federal rule, they have magistrate judges, and they are allowed to conduct pre-trial matters in the case, like discovery, for requests for, information for documents. And as long as it doesn't involve, they cannot make a decision to dismiss the case. Only the judge can do that, unless you consent to a magistrate. So your audience understands, if you're in a federal court case, immediately you're going to get a notice from the court immediately after you file the case. It's going to ask you, do you consent to a magistrate? In other words, if you consent to the magistrate, then no, by the way, both sides have to consent to the magistrate. If either side does not consent to the magistrate, then the magistrate cannot make the decisions, all of the decisions in the case. He can only do the pretrial stuff. But if and a lot of times they do, both sides will consent to it. Usually you can get a quicker trial and so forth. Me personally, I don't like it. I would rather have the district court judge, because it adds another layer. Because if you don't like what the magistrate's doing, they have another rule where you can file objections to the district court, and that all takes extra time too. So to me, I'd rather have the district court do it. And so I don't consent, and I didn't consent to this one, but he's got the right to issue rulings. Like right now, we're in discovery right now. They want my deposition. They're actually going to dig into my computer for metadata for my email accounts and all of this and all of that. And the judge is allowing them to do it, and it's just there's a lot of nonsense involved with it. And but this magistrate, I'm a little uncomfortable with his rulings, how he's proceeded in the case. He actually threatened me just not too long ago, just a few days ago, when this Ellis wrote the letter to him that I just spoke about. Then I filed, I submitted my response to that letter, and then we had a telephonic conference shortly after that. And then the judge said, hey, only motions should be filed, no letters, do everything by motion. But he didn't chastise Ellis. He didn't threaten Ellis for sanctions for writing that letter to him. Now, that's very important here because just a few days ago, I wrote a letter to the chief judge of the Northern District of Indiana. Every district in federal court has a chief judge that oversees all of the judges in that particular district. In federal court, they all have it. So I wrote a letter or an email. I sent it by email. It was a letter, and I sent it as an attachment to the email. So I addressed my concerns to the chief judge about this magistrate, Martin, about things that he's been doing in the case. And I discussed this letter as well. And then he got really mad when I sent that communication to the chief judge, which I had a right to do, by the way. So then what happened was I copied him on that communication. And I copied all of the lawyers in the case on that communication. So it would be on the up and up. So it would not be an ex parte communication in secret. So then what happened was he just issued an order a couple of days ago. I'm striking the letter that Vukadinovich wrote. I'm striking the email, and then he cautioned me, he threatened me with sanctions. If Vukadinovich violates any rules or court orders, he should know that he will be subject to sanctions. He actually threatened me for doing something that I had a right to do. So I responded to that already. My response is filed. First of all, it was not an ex parte conversation because I copied him on the communication. Had I not copied him, if I would have just sent it to the chief judge, then it would have been an ex parte. So he was completely wrong about that. Completely, 100%. And secondly, he threatened me with sanctions that if I violate any court rules or orders, that I will be sanctioned. But he didn't say what rules or court orders I violated. He didn't say what rules or orders I violated because I didn't violate any rules or court orders. So it was entirely inappropriate for this magistrate judge, John E. Martin, to threaten me with sanctions for something that I didn't do. So that gives me cause for alarm because he's basically doing what Ellis asked him to do in that March 8th letter when he wrote to this judge and he asked him for help and assistance to put this case to a swift end. And now shortly thereafter, after I did something that I had every right to do by communicating with the chief judge and copying him, that he threatened me for it. These are the kinds of things, but that's not going to work. I know he's mad, but you know what? If you're going to take an oath of office, an oath, a sworn oath as a judge to uphold the Constitution and follow the laws of the land, they all have to take that oath, then you have to do that. You can't act inappropriately, and then when a party does something they're entitled to do, then come back and retaliate against them. And that's exactly what Martin did. And now this Ellis now going forward, because he's already he's asking for sanctions at every turn here now. Every time I file, so I just filed a few weeks ago, I filed an objection to some rulings that Martin had made, which I have a right to do under Rule 72 of the Federal Rules of Civil Procedure. So I follow Rule 72. I file my objections. Those goes to the district court, not to Martin. They go to the district court. I have a right to do it. I did it. And then Ellis files in court papers that I should be sanctioned for filing that objection, which I had every right to do. So now I know he's waiting now. Now he's going to say, hey, listen, Judge Martin just threatened Vukadinovich with sanctions. We should sanction him now at every turn. That's what's going to happen. That's what's going on in the court systems in the country now. That's how these courts are bullying people. It's judicial thuggery is what it is. They bully people. But I'm sorry. I'm not sorry, because I won't apologize for my actions of standing up. I believe people should stand up in court. I call a spade a spade. If the judge does something inappropriate, and this judge, John E. Martin, he certainly did something inappropriate when he threatened me with sanctions because I exercised my right and I submitted a communication to the chief judge. I reported him for his inappropriate conduct, that he got so mad about it that he threatened me with sanctions. You have to stand up to these judges, and you cannot allow, and I know a lot of people, I've talked to a lot of pro se's all around the country, and we have these discussions, and they tell me about how they're getting a shaft job. The lawyers are running all over them in the courtroom. The judges are running all over them in the courtroom. And I tell them, you have to stand up to these people. If I do, the judge is going to get mad at me. If they take it like I'm talking back to them or something, and then they're going to, hold it against me. And what I say to them is this: well, you just told me that they're already giving you a shaft job already. So you know what direction they're going already. So the choice you have to make is take it, let them walk all over you, or stand up and be heard. And so I tell them, it's a mistake to sit back with it. Pro se's have to, first of all, if you're going to represent yourself, you better know what you're doing. It's not an easy thing to do. It's very, very hard. It honestly is. And it actually doesn't need to be. But the court system set it up that way. They've got a lot of rules. For example, a lot of pro se's tell me that, I'm one of the few people in the country. I'm not real, as we talked earlier, I don't know how to do a lot of stuff with the computer and stuff. I file my stuff either in person or in mail. I don't do it. They have an electronic filing system. In federal court, it's called the PACER system. So if anybody's involved with the federal litigation, look up PACER, because there's a way you can pay every month and you can do electronic filings and so forth. But a lot of courts are disallowing the pro se's from filing electronically. It's happening in state and federal courts all over the country. So they make the pro se's, they have to spend the money to make the copies, then they have to spend the money. And, a lot of times, sometimes you're filing stuff 20, 30, 40 pages, on whatever they got to pay for, each copy. Then you have to mail it. And actually the post office isn't cheap anymore either. It's $4 or $5 just to send a little package to the court to file it. So they're making the pro se's do all those things that they don't make lawyers do, which is discriminatory, but that's part of the system and how they have it set up. In fact, you and I talked a little while earlier, the Supreme Court of the United States actually has a rule. I believe it's Rule 28 of the Supreme Court rules. They actually have a rule. Now, remember this is the Supreme Court, the highest court in the country who are supposed to be upholding and enforcing everybody's rights, okay, including the rights of the pro se litigants. They have a rule, I believe it's Rule 28, where they do not allow pro ses to be involved to conduct the oral arguments in front of the Supreme Court. If it's a pro se case, irrespective of how strong the case is, you're pro se, we do not allow you to address us at an oral argument. It's supposed to be about the issues in the case, not your standing, not because you can't afford a lawyer. If you were savvy enough to write a brief and the Supreme Court accepted that brief and they accepted the money, it costs a lot of money to file. It's like almost $500 for a filing fee in the Supreme Court, just to file a petition, or it's a writ for certiorari, they call it. And I think it's $470, somewhere almost $500. And you have to, and it's almost, I'm gonna tell you, it's really, when you're in a regular court case, you make copies, you file them, and you're done. In the Supreme Court, they require it. It's not like just staple it with a stapler. You have to go to a printer, a publisher, or a printing company, and they require books. The actual briefs have to be in book form. They actually have the size that the book has to be, and they actually even say this is how thick the paper has to be, and this is the type of font that it has to be. A person couldn't do that on their own. They would have to go to a printing company to do that, and it would be probably a few $1,000s to do it. And in addition to that, they require, I can't remember the exact number, but you have to file, it's like 30 or 40 of those books. So if the printer is charging you, let's say $100 per book, you have to file, and I can't remember the exact number, but it's a lot, 30 or 40 of them. So it's almost like, the money alone, you can't afford it. And let's just say by chance you did all that, and then let's say they voted to accept your case, but they won't allow you to have the oral argument. In other words, they don't want to hear from you because you're pro se. That's wrong. That's wrong. But this is what's happening with the pro ses around the country, and they're getting away with it. What people need to do, and that's a rule. That's not a law. That's not written in the Constitution. There's a big difference between a rule and a law. That's a rule that was conjured up by the Supreme Court. It's a rule. So why the Senate Judiciary Committee, they could hold hearings on it. They could call John Roberts in and say, hey, listen, tell us about this rule, why the Supreme Court won't allow the pro ses to conduct oral arguments. Is that fair? They should be doing that. But see, the Senate Judiciary members, they won't dig in on behalf of the regular people. They just simply don't want to do it. It's sad, but that's what's going on. That's why the people in our country are getting a royal screw job from the court system. It's horrible. It's terrible, that we're paying all this money, for what we believe, we're going to get some justice and some fairness, and we're not. It's a very, very unfair system. And, something needs to happen. And it's not going to happen until the people stand up and be heard and contact, every person. There's 2 United States senators in every state. Okay. If you're involved in federal court and something's going on and you're getting a screw job, and there's something just like what's going on with me right now with this threats of sanctions, I'll deal with those. I'm not going to get any help from any politicians. I know that. I'll deal with them, and the court's not going to like it, but I will deal with them. Trust me. And then people need to, scream out loud about it. People are protesting all around the country for a lot of different things, political things. They're all out on the streets. There should be mass protests around. Everybody gets affected by court decisions on a daily basis. It affects everybody, whether you've been involved in litigation or not. Everything that happens in court decisions from the Supreme Court on down affects people in one way or the other. And we expect and deserve a fair judiciary. And just for starters, We do not need a Supreme Court to put in a rule forbidding pro se litigants, unrepresented litigants, from being heard in front of the Supreme Court. And in fact, that is the case. There is a rule by the Supreme Court for that. And that's very wrong. They should take down on the front of the U.S. Supreme Court, it's engraved in the front of the building, equal justice under law. It's engraved right on. Well, that's not equal justice under the law. If I'm in the Supreme Court with a case and I'm battling somebody that has a lawyer and my case is strong and the Supreme Court, well, we have a rule, we don't want to hear from you, that's not equal justice under the law. I'm sorry. That's a very, very bad thing for our country. And this is what's happening. And people need to wake up and smell the coffee. There's a lot going on that I could talk about, and I think we probably will talk about in the future. But I'm going to give you, if it's okay, I'm going to give you some more examples of what's going on in this particular case right now, in my case right now, just to give the people an idea, and it's probably going to raise some eyebrows. And what I'm going to talk about here, I've got the documents. I don't make anything up. In fact, some people will ask me, you wrote those 2 books, you name judges, you call them by name corrupt. And some people ask me, aren't you afraid of being sued? You call the judge by name corrupt. That's an easy answer for me. No, I'm not at all worried about being sued because I can back up. If I call a judge corrupt, I can back it up. If that judge wants to sue me because that judge said that I somehow defamed them or libeled them or whatever, have at it. Then sue me. I'm not worried about it. If you want to have a trial, if a judge wants to have a trial and claim that I somehow defamed him under the law or libeled him under the law, if he wants to have a trial, then sue me, and I'll be happy to walk into a courtroom and talk to a jury about how corrupt that judge is. I mean, you can't just go out and just say stuff about, you have to, be careful about it. You have to be, you have to know, you have to be able to back up what you say. And I back up what I say. So if I call a judge corrupt, that judge is corrupt. And I call him out by name. And I'm going to tell you, I'm getting close here in my case here. I'm getting close. Just this stuff with this letter and the way these rulings are happening. When this case, before this case was ever filed, I gave Posner an opportunity. Now, just so the audience will know, he heard about how I won that federal trial. It was in 2016. You mentioned it earlier. I represented myself. It was in federal court. It was a 5-day jury trial. It was against my former employer. I was a teacher, and I lost my job. They called it a RIF, a reduction in force, they call it, which was baloney. And I said it was baloney from the beginning because there's a lot of politics with stuff behind the scenes with me that could be another show. And I knew that was what it was all about. So I challenged the school district on terminating me. And they very stupidly refused my request for a meeting with the school board. Now, for your audience members, if they're public employees, particularly if they're school corporation, like if they're teachers and if they're public employees, you have certain rights that are involved that you may not get in other forms of employment. Like if you're working at a grocery store, there's a lot of things that you don't have as far as rights that you'll have if you're a public employee working for a governmental agency. Due process, the 14th Amendment. You have a right to be heard before you're terminated under the law with public employment. So what happened was I asked for a meeting with the school board. I wanted to, express to the school board, hey, this there's got a bad smell to this thing here. This new principal that walked in the door here, not good here. What he's doing here. I want to state my case to you here. And I've been a good employee, all solid evaluations and so forth. I was on tenure and everything. And no, we're not meeting with you. Talk to the superintendent. So what do you mean talk to the superintendent? You're my employer, not the superintendent. You're the public body that employed me, okay? I have a right to have to come in and express my grievances with you. They said no. Huge mistake. So I went through their process that they required. So I never got a meeting with the school board. So I had to meet with the superintendent. They called that my due process meeting. So they called that. So the superintendent rubber stamped the principal, the one that called me in and terminated me. So I said, that's not proper due process. You're just rubber stamping. I want to meet with the school board because they're everybody's boss, the superintendent's boss, everybody's boss. They wouldn't do it. So before I could file the case in federal court, by law, if it's an employment case involving a public employee, you have to first file a complaint. I hope I'm not boring the audience here, but there might be people out there that are maybe involved with something like this or may get involved with something like this, so they'll know what they need to do. So a lot of people think, well, they'll just run to court the next day and file a lawsuit. You can't. If it's a public employment type case like that, it involves due process issues and so forth. You have to first file, you have to go to the EEOC, the Equal Employment Opportunity Commission. They're in all the states. They'll have offices, several offices in the state. So you go there and you file a complaint there against the employer. And then they will supposedly investigate it. And then they will come to some type of, determination. And they could issue a ruling, the corporation was wrong, or the corporation was not wrong. They could make a determination. Or they can say, you know what, we just don't feel like we can make a determination. Then they issue you what's called a right to sue letter. Once they issue the right to sue letter, then you can go immediately to court, but you can't do it until you get the right to sue letter from the EEOC, just so the audience will understand that. So then a lot of time went by, and I'm contacting them. Hey, are you guys ever going to make a determination here? Well, see, it's a government agency, just like anything else. They probably got a lot of stuff. The files are probably all backed up. They can't get to stuff. And so I told them, I said, listen, if you can't get to this here, issue the right to sue letter so I can just take this into federal court so I don't have to wait another 4 or 5 months here. So they issued me a right to sue letter. So then I went to federal court and I filed the lawsuit in federal court. And I represented myself. School Corporation had a bunch of lawyers. They had them, Illinois, Indiana, Indianapolis, LaPorte, Chicago, and all of that stuff. So it took 4 years for me to get the case into trial. And the judge, his name was Philip Simon. At the time, he was the chief judge. A little while ago, I talked about this other chief judge. But at that time, Philip Simon, he was the judge in my case. And I have to be fair here. I'm critical of judges, but if they're decent judges, you have to say that too. They're not all bad. Now, I have to be honest. It was kind of a rocky road for a while with him. He didn't like it that I was representing myself, and he let me know that. And I kind of took exception to that, honestly. One time, we were at a hearing and he was pressuring me to get a lawyer, So I said, no, I want to represent, I wanted to represent myself by choice. I did not want a lawyer. I don't trust lawyers. That's a whole new ballgame that I could talk about. That would be another show, but just to make a long story short, I don't trust lawyers. I don't like them. I don't trust them. I'm just being honest about it. And I didn't want a lawyer. I could have gotten a lawyer. I could have afforded a lawyer. I didn't want one. So I made it clear to him, I will represent myself. And he didn't like it. And then roughly a year later now, the case is progressing. Now we're getting close to trial. And he brought it up to me again. And I'm like, oh, I can't believe he brought this up again. So I told him, no, and he asked me, he said, do you want me to try to, I'll see if maybe I can get a lawyer, for you. And I said, no, I don't want you to get a lawyer. I don't want any judge selecting a lawyer to represent me. That's the last thing I want. Any judge. I didn't have anything personal against him. I thought actually he was an okay guy, actually, to be honest about it. But I don't want any judge, deciding who my lawyer is going to be. I said, no, I will represent myself. And then he said to me, well, you know, when that jury sees you without a lawyer, you know what that's going to look like? Those were his words to me. Okay. So I said, well, you know what, Judge? You know, a lot of people in the country don't like lawyers. Okay. So I'm okay with it. His thought process was, well, you're in here without a lawyer. And there's something to be said about that. Well, the jurors, they see you without a lawyer. He must not have a strong case. Otherwise, he'd have a lawyer. I think that's what he was probably trying to message to me, I guess. He didn't say that, but I guess that's what he was trying to convey. But I told him, no, I do not want a lawyer. I will represent myself. And then we proceeded on. Then about 2 weeks, it was 1 week or 2 weeks right before the trial, he got real mad at me because we had a hearing, getting ready for the trial. We were getting everything rule, you know, all the rules. This is how we're going to do this. This is how we're going to do that. And we got all that done. Then he said, okay, now let's have a settlement conference. Let's take a shot at it. Maybe we can get the case settled. Okay. Now remember, the case is 4 years old. We're a week away from the trial. I've had to go through all of this stuff with these lawyers now. And they could have settled the case 3.5 years before that if they would have wanted to. Instead, I had to go through all of the stuff. And see, now remember, now they're making money all this time. See, they could have settled the case. See, these cases, a lot of times they call it settle the case on the courthouse steps, is how they say it. The case will go on, and right, you're walking into the trial, and right away the lawyers say, let's settle it. You know, sometimes they do it right in the courtroom. Okay. They did something they could have done 2 or 3 years earlier, because they don't want to settle the cases, because then they don't get to make the money. All these lawyers got to make a lot of money off of my case for 4 years. And then when push came to shove, when we were a week away from the trial, let's settle the case now. Okay. So the judge, so he says to me, he had them in one room, and he told me to stay at the table there. And then he was doing the back and forth thing. He'd go talk to them and he'd talk to me. So he comes out there and he says, well, they're willing to pay you $150,000 to settle the case. $150,000. Okay. That's a lot of money. Okay. Of course, that's a lot of money. I said, no. I didn't bat an eye with it. No. We're going to trial. Okay. And he didn't like that. And I told him, I said, these were my words to him. I said, I'm going to expose them for the liars that they are. That's what I said to him. They put me through all of this. They gave me a very unfair process when I lost my job. And then they put all these lawyers on the case, and I got to do all of that nonsense for 4 years. And there were so many lies that involved. I had it all documented. I had their depositions. I was ready for the trial. I had their depositions. I had everything. So I told him, I said, no, I'm going to expose these for the liars that they are. And then he said to me, I don't think you're going to win. I thought to myself, you're the judge and you're already making a judgment that I'm not going to win. You know, that's wrong. You know, for a judge to say, well, I don't think you're going to win. Okay. So I didn't want to get, testy with him or whatever. I did kind of like him, actually, to be honest about it. I didn't think he was corrupt or anything, but I thought he was slandering things quite a bit for the corporation for quite a while. And I'll talk about that in a second here. But I thought he was actually kind of okay. So then he said, well, I don't think you're going to win. He was like saying, you better take the money. Okay. So I said, no. And he gave me a real dirty look. And that's how we parted company then. Then the next thing was the trial, which was like a week or two later then. Okay. That was the next time I saw him then. Okay. So then we're at trial now. I got my table over here. They're at their table. We've selected the jury, that's a very important, your audience, if you go through a jury trial, do your homework on that part, because that's extremely important, who is that. And, there's a major process involved with that, with how many jury strikes you get. And you got to be real smart about how you go. We can probably talk about that sometime down the road. If your audience would be interested in that part of it, it's a very important part. So we selected the jury, and So I said to myself, just to myself, I said, man, you've got to let this jury know within 5 minutes, okay, what you're about. If you go in there and bumble around as a pro se immediately and you're messing up, you don't know what you're talking about, and the judge is correcting you, and no, that's wrong, you can't do it like that. Right away, the jurors now, we got to go through this now, they're already going to start an impression about you. The guy shouldn't even be in court. So I said to myself, first 5 minutes, man, let them know that I know what I'm doing here, that they're actually going to focus in on what I'm talking about instead of having an attitude. What's this guy doing in here? Okay. So immediately, boom, we got the case started, started the testimony. I did my opening statement, which is very important. Did the opening statement. I felt really good about that. And then they did their opening statement, and then we started the trial. And then the trial lasted 5 days. We started on Monday and it lasted till Friday. I put the superintendent on the stand. I put the principal on the stand. I put several school board members on the stand. A couple of 3 principals, two of my principals and an assistant principal all testified for me. Joe Fetty was the principal that hired me, principal of the year in Indiana, highly respected principal, 28 years principal there. And he testified on my, for me at the trial. And another principal, another assistant principal, Jeff Brooks, good guy, he's a superintendent now. So the jury saw, hey, you know what? The guy was a teacher, he had good evaluations, he's got solid people testifying for him. Let's hear him out. That's important at a trial. But on the other hand, I put the superintendent on the stand, and I put the principal on the stand, and several of the school board members on the stand, and they lied out of their teeth. And I had the depositions. I had already taken there, and it was a lot of money. It cost a lot of money for those depositions, but it was very important. So, they testified to one thing, then I get them on the stand, and they're testifying to another thing. So now you can impeach them now with their prior testimony. So then I said, no, wait a minute, that's not what you said. That's not what you said when I took your deposition. You said quite the opposite. And then I would hand them the deposition, and they would read it, and they knew they were in trouble. And then the judge made some rulings, and so forth. Sometimes they didn't want to answer questions and so forth. So everything was going good. And the superintendent, the stupidity of the superintendent, she actually testified that now remember, due process, you have a right to be heard under the law as a public employee. They can't fire you until they hear from you. You have a right to ask questions and receive answers. So then, okay, you're going to have your due process meeting with the superintendent. So I had the meeting, and then so when I put her on the stand, I said, did you ever tell me why I lost my job? That was the whole case, actually. Okay. So my question to the superintendent, did you ever tell me when I met with you why I lost my job, why I was losing my job? And can you believe, I could not believe this. I almost fell over. She said, real sarcastically, she said, well, you didn't ask. She said, well, you didn't ask. Those were her words. I about fell over. So I said, I didn't ask. I said, well, isn't that why I had the meeting with you, to find out why I was losing my job? See, that made no sense. See, and the jurors are watching all this. See, so I said to her, I said, well, wasn't that the reason we had the meeting that we had? So I could find out? And they're all taking this in now. So I felt really good right then. And then now I'm going to go forward now, fast forward. The school board president had already testified, and now the trial's over. Okay. As far as, now we're going to get into the closing arguments and so forth. So I told the judge, I'm done. I rest my case, I'm done. And then the lawyer for the school corporation, I could not believe this. Oh, we're going to recall Mary Joan Dixon, the president of the school board. We recall her back to the stand. So I'm like, what in the world would they bring her back on? I already fried her the first time around. But I was, oh, fine, no problem. So they put her back on the stand and they asked her 3 questions. The lawyer asks her 3 questions. Question number 1. Did the superintendent provide all of the due process to Mr. Vukadinovich that he was entitled to? Her answer, yes. Okay. Question number 2. Did the superintendent, Kaiser, did she provide all of the information to Mr. Vukadinovich that he requested? Yes. Question number 3. Did Miss Kaiser, the superintendent, did she answer all of Mr. Vukadinovich's questions at the due process meeting that she had with him? Yes. That was it. Okay. Well, now I get to cross-examine her. Okay. Could not wait to get to the podium. I wanted to run up there. So I said, all right, now you just testified, your lawyer asked you if Miss Kaiser provided all the due process I was entitled to, and you said yes, correct? She said yes. Then I said, and then she asked you if she provided all the information that I asked for, and you said yes. Is that correct? Yes. It was always yes. It was yes to the other one and yes to me. I said, okay. Then the last question she asked you was, did Miss Kaiser, the superintendent, answer all of my questions at that meeting? And you said yes, correct? Yes, she said. So then I said, all right, now, my question to you is this. If you were not at that meeting with me and Kaiser, remember now, they wouldn't meet with me, the school board. If you were not there at the meeting with me and Kaiser, then how would you know that she answered all of my questions? We're done, okay? She looks down, and she's got a big mouth. She's all over the place, blabbing stuff all over the place. She looks down. I said, I need an answer to the question. So I asked the judge, please instruct her to answer the question. So he told me, you got to answer the question. She looked down, and you could barely hear her. She said, this is what she said. This was her testimony when I asked her that. Well, I guess I don't know. And I said, well, I guess you lied. And then we were done. Then I went back to the table, and now we're done. That's how the trial ended. I said, well, I guess you lied. See, they just heard her lie. She testified to the jury. Oh, yeah, she answered all the questions. She lied to the jury. Okay. And then when I got my chance to go up there, I showed how she lied. I could not believe that lawyer put her on there to do that. So then we had closing arguments. He gave us 50 minutes, 5-0. So the rule is the plaintiff gets to go first, and if he wants to, he can go last, or he can do it all at one time, whatever allotted time you get. It was a 50-minute closing argument he gave us, but the other side has to do all theirs at one time. So I made a decision that I knew I didn't want to do it all at once. I wanted to go back up have the last word. So I told the judge, I want 30 minutes for my first part, and then I want to come back with my last 20 minutes. Okay. So the first time I went up there, I took my legal pad with me. I had all my notes on there. I talked about the testimony and the evidence and so forth. So I went through all of that the first time. And then I was finished. And then they went up, and 2 of them went up there and talked and addressed the jury, and then they had 50 minutes, and then they're done. So the last 20 minutes, I didn't take a clipboard, I didn't take a legal pad with me. I just went up there and talked to him. Okay. I didn't want the lawyer nonsense, the law, the rule. I just talked to him from the heart and told him about how I got screwed out of my job. And I emphasized over and over and over how not only did they screw me in the termination process, but they lied to you, the jury, doing it. And I kept talking about how I said, remember when the superintendent testified that I didn't ask for the reason that I lost my job? I said to the jury, I said, you've watched me in here all week now, okay? You've watched me. You heard her say, well, I didn't ask. I said to the jury, do I look like the type of person that doesn't ask questions? Because they saw me all week asking questions. So they knew that had to be a total lie by that superintendent. And then I hammered the point home. You heard the school board president lie to you, told you she answered all of my questions. And then when I pressed her on it, she put her head down and said, well, I guess I don't know. And then I said, I guess you lied. And then the judge said, and I'll finish this up here because I don't want to bore everybody with it, but I know a lot of people like to hear the stuff that happens at a trial. So the judge said to me, he already said ahead of time, where he said, I'm going to tell you when you got a minute left, and I'm going to tell you when you got 10 seconds left. Okay. Because he wants you, when you're done, you're done. And he's timing all this, with the time. So he said to me, 1 minute. I knew I had 1 minute left. So in other words, wrap it up, whatever you got to say. You got 1 minute. It's okay. I got 1 minute now. And then I had the 5 seconds that he told me. And I don't know, I didn't at all think about this ahead of time. But when he said 1 minute, okay, I just instinctively, I just turned around and I pointed at their table, the lawyers and the school officials. It was with my left hand. I turned around and I pointed at them and I called them liars several times. And I kept my finger out at them. Now, I kept thinking, I don't know if the judge is going to get mad, but it wasn't anything, wrong actually. But sometimes I get, like bent out of shape with some stuff. And I didn't know if the lawyer was going to object. I know they didn't like it. But see, the problem they would have is if they object, if the judge doesn't go for their objection, if he overrules it, then the jurors see that. And then, the judge told them to jump in the lake, see, because they were afraid to object, although I know they didn't like it. So I just pointed. I wish I could have had a video of it, just to have that, for a keepsake. And, I called them liars, as I told the judge I was going to do when we had that meeting that we had. And that's how I closed the case. I was able to point that out. I called them liars, and I felt good about that because that's what they were. And then we were done, and I felt real good about things right then. And then a half hour later, we had a room there in the courthouses. You have a room for your stuff. You have a table and all that. I'm in there with some friends. My brother was in there with me and so forth. Somebody knocks on the door, and I didn't know who it was. I saw him sitting there in the audience, and I didn't know who he was. And he said, "Hey, could I talk to you for a minute?" I said, "Well, who are you?" Okay. And he said, "Well, I represent the insurance company. Do you want to settle the case?" Okay. So I said to him, I said, did you watch I know he did. I was being sarcastic. I said, "Did you watch the trial?" "Yeah." I said, "Well, how much are you offering?" He said, $50,000. I said, "You got to be kidding me." I said, the judge told me $150,000 before the trial, and I turned that down. I said, "Did you not watch this trial?" So get out of here, but they tried it. They knew they were going to lose. So then we were in the room I had there, and then some of my friends were in there, and then one of my friends came in. He's somebody that I taught with a long time ago, and he came in there and he said, "Hey man, listen," he said, you should see them out there." He said, nobody's moving. It looks like they're like statues. Okay. They were all numb because they knew they were going to lose. So then I thought, I got to see this. So I acted like I was going to the restroom. So I would have an excuse. I didn't want to go out there and just, do all of that stuff. And man, it was like the Twilight Zone. It's like you're watching a segment of the Twilight Zone where everybody's just frozen like in time. They knew what was going to happen. And then about 3.5 hours in, the court report, the court, she was like the court official, in charge of the case. She was the case manager, I guess. She came out and she said that no, the judge came out the first time, about 3.5 hours in. He said, I thought he was going to say, hey, listen, it's getting late, and let's just adjourn and we'll come back Monday. Well, if that's what he wants to do, I couldn't control that, but I wanted to stay because I knew I had him in the closing argument. I wanted to have that effect. I didn't want to have the weekend and then you lose the effect. So I said, oh, fine, great. He said, well, we're going to let him go to lunch right there in the courthouse. They had the thing there. He said, we're going to let them deliberate over lunch if they choose to, if they want to. And then they came back, and then we came back, and then about an hour and a half later, the lady, the case management person in charge of the courtroom, she came out there, and I thought for sure now she's going to say, we don't have a verdict yet. We're going to come back Monday. She comes out and she says, the judge wants everybody to come back into the courtroom. We have a jury note. And right away, I don't know if anybody in your audience has ever watched the movie The Verdict with Paul Newman in it. It's a great legal movie. It's called The Verdict. Paul Newman was a drunken lawyer down on his luck and just couldn't win any cases. And then a case came to him and he was getting a shaft job with the insurance lawyers, and the judges were messing him over left and right. And then a new judge came in and changed everything. Okay. And then he sobered up and he won the case, and it was a big deal. He was just a drunken lawyer down on his luck. And then when a judge came in that actually wasn't giving him the shaft job, he was able to win the case. They had a jury note in that case. There was a big thing at the end of the movie, the jury note. And the jury said, can we award more damages than are being asked? That was a jury note. So as soon as she said there was a jury note that the judge wanted us to hear, I immediately thought about that. The verdict, they had the jury note in there. And we get in there, he reads the jury note. The jury is requesting a calculator. Okay. Well, why would they need a calculator if they're figuring out the damages? Automatically, everybody knew they, I won the case. That's how, and then, maybe a half hour later, then they decided, and then they awarded me a little over $200,000 for the case. So I ended up getting more than $54,000 more than, what the judge was trying to push me into, accepting, and got to expose them for the liars that they were. And it was very important for me to be able to show, and I'm not just saying this was very important that I could now say, as we're talking here right now, yes, it can be done. Pro se. It can be done. It's not an impossible thing. It's a very difficult thing, but it's not impossible. I did it. If I could do it, you can do it. But there's a lot involved with it. But it can be done. That's the message. That's the moral to the story. It can be done. But it's difficult. And right now, I'm going through. How are we with time right now? Are we okay?
We have, well, if you wanted to go 90 minutes, we have about 15 minutes. I'm good to go a little bit longer though, if you want.
Okay. I just don't want to, I don't want to talk too much. I don't want the audience getting bored. I want the audience to, things to sink in on what we're talking about. So I hope it's interesting.
It is. I really appreciate you sharing all this because, like you said, this can happen to anybody. It's so common and we're so uneducated. So it really helps having somebody like you walk us through a real case and getting to see sort of the step by step. So keep going.
This way, the message I'm trying to get across is it's tough, it's hard to do. There'll be a lot of resistance to what you're trying to do, but you just got to be real strong about it as you're going along. And you got to fight for yourself, in a lot of different ways sometimes, with the lawyers, with the judge, but you just got to do it. So those are the examples, that I've been pointing out here. And when you're putting people on the stand, you got to do your due diligence with that. And we can do some shows on that sometime down the road on how to prepare for cases and so forth. So in this, right now with what I'm going through here, and I'm dealing with things in my current case. And by the way, it's in the same courthouse as that trial that I just got done talking about. We're in the same courthouse, different judge. Kind of wish I still had because he actually wasn't, even though there was some things, some rocky start with some things, he actually was okay. In the end, he gave me the trial. A lot of them wouldn't do it. So, he did do that. So I do have to give him credit for that. And there's ways that they screw people out of trials. They're doing it all the time. And he didn't. But we are in the same courthouse. We got different judges. And I'm not gonna make any bones about it. I'm not comfortable with them at all. I'm not comfortable at all with this magistrate judge, John E. Martin. And I'm sure this lawyer, Ellis, is watching this. The reason I'm sure of it is because he's basically obsessed with me. Okay. He has been, I've done some other interviews on some other shows. And this guy, Ellis, okay. You see this pile of papers here? There's probably, I don't know, a ream of paper is 500 pages. This might be a little bit more than a ream, okay? Every single page here, okay? Now these are, different filings that he's made in the case. This one here is 213 pages, this particular packet here. And altogether, they're probably between 600 and 700 pages. And you know what these are? What these are, this Ellis has been tracking my interviews, and he is already in the case, believe it or not, a lawyer who should know that in this country, people have a First Amendment right to speak, free speech. He's been complaining in the litigation about the books that I wrote. He's been complaining about interviews that I've done. So I've had to address that in the case. It's got absolutely nothing to do. The case is breach of contract. His client doesn't want to pay for the work that I did. Okay, I'll talk about that part of it in a second here. But he's been obsessed with me. And for example, as I said, this is probably between 600 and 700 pages here. This particular one here, he filed 212 screenshots of me. These are screenshots of me doing interviews, and he filed them in the case. This particular packet has 212. This one here has 168, and there's like 600 or 700 of them altogether. And he's also he's screenshotted some of my Twitter tweets too, as well. So he's obsessed with me. He's worried about me beating him in this case. That's why he had to write that letter to that judge, Martin. Help me, give me some assistance here, okay? He's totally obsessed with me. So to the point, when I saw this, there almost has to be something wrong with somebody taking the time to do that many screenshots of somebody. So he's probably watching this, and probably as well will file this as well, and I'll address that as well. But there's something very wrong with that picture. He's trying to impress the court with the fact, look, Judge, Vukadinovich is talking about the court system. So therefore, you should be biased against him. You shouldn't like him because look what he's doing. Well, you know what? I know the judge doesn't like it. Too bad. The judge is a judge. He's supposed to respect the First Amendment. If the judge doesn't respect the First Amendment, then you know what? Then whatever judge doesn't respect the First Amendment is going to retaliate. Then that judge is a piece of garbage. I'm sorry. I'm just going to say it. But that's what the point of all. What other point could there be? Could there possibly be? Like I said, look at all of them. He's obsessed with me, this guy, New York lawyer, big shot lawyer from New York. Now, before I even file the case, I gave Posner an opportunity to settle the case. I told him, you owe me the money. It's time to pay up. I sent him an email. He didn't respond back. Then I sent him a letter. After the email, I sent him a letter. Then apparently his wife gave another lawyer in Chicago, the letter. So I get a letter back from this lawyer in Chicago. This is before I file the case. His name is Robert W. Kaufman. He's with a firm in Chicago, Official Con. Okay, this is the letter. So everything I'm saying here, I'm reading right out of the letter. It's dated February 28th, 2022. Here's what he said to me, in part. Okay. What you clearly do not know is that soon after your conversations with Judge Posner in early 2018, he received a confirmed diagnosis of Alzheimer's disease. He has long since moved to a nursing facility and for that reason never received the emails you sent and would not have been able to respond to them even if he had. Then he said, as this is a quote now out of his letter, as to the substance of your claim, we believe that medical evidence will show that the judge did not have the legal capacity to enter into contracts in 2018. So, this is the lawyer. The medical records are going to show that he didn't have the legal capacity. He couldn't think for himself, in other words, okay? Okay, now we're in the case and we're in discovery. So, they should be producing those medical records now to prove this up. This is what the lawyer told me. And they even stated in their affirmative defenses in the case, they even stated as affirmative defenses, this is what, several of them, but this is one of them. Their fifth defense, they titled it incapacity. Plaintiff's claims sorry about that. Plaintiff's claims fail in whole or in part because defendant lacked capacity to form a binding contract. So they actually stated that as a defense. Well, then now I'm entitled to the medical records now, because you have to prove, if you're going to say he didn't breach the contract because he had something wrong with his thinking and so forth, then you have to prove, and his own lawyer said the medical records will show it. Well, now I've asked for those medical records in the case. And guess what? This lawyer, Ellis, who wrote the letter to the Judge Martin, help us, give us some assistance here. He now is objecting. He doesn't feel that they should have to provide all of those records to me for all of this nonsense and all of that nonsense. Okay. And and he also stated on one of the defenses, plaintiff's claims are barred among other reasons. Plaintiff, get this, plaintiff knowingly induced defendant to enter into the alleged contracts. Plaintiff knew that defendant lacked mental capacity to do so. This guy actually, first of all, their own lawyer, his first lawyer is saying, clearly I didn't know about, how would I know that, who's going to go around advertising that? How would I, and his own lawyer said that I didn't know it, okay? And then I received an email from his own wife, Posner's own wife. I received an email from her telling me, she apologized to me for being, quote, now these are her words, not mine, so misled. She stated to me in an email that I was, quote, so misled. And now this Ellis now is playing all these games, knowing he's got a losing case, and the only way that he can get out of this case winning this case is by putting the judge in his back pocket. And I'm concerned about that because of the letter that he wrote to the judge. And then I'm further concerned, this judge, after I reported all this to the chief judge, then he all of a sudden turns around and threatens me with sanctions. So, I have to seriously wonder, is he now doing what Ellis asked him to do? So we'll see. We'll see what happens with all of that. But I will address it. I will clearly address it. I'm going to tell you something else this lawyer, Ellis, did to kind of wind things down here, to show your audience how things go in these cases, the dirty tricks that are played in these cases. Ellis, the lawyer from New York, he recruits this lawyer in Chicago. Her name is Sakina Carbide, Carbide, Sakina Carbide. I worked with her in the Posner Center. So I worked with her. She did some stuff, and I was the executive director, and I had to do stuff with lawyers and so forth in the case. So I worked with her on some stuff. But lawyers are lawyers. I was real surprised when I saw this. Not too long ago, Ellis he's trying to do everything he can to try to prevail in the case. At any cost, let's win the case at any cost. So in addition to everything that I've already talked about, he brings Sakina Carbide, he gets her to sign an affidavit, okay? And her affidavit, now, this is her affidavit, okay? This is her affidavit right here, okay? And she said in the affidavit, she swore, hey, I was at a lunch with Posner and Vukadinovich in Chicago, and Posner. Now this is where Posner and I finalized. We had we started out initially. He emailed me and asked me to work for him, and he said that he was going to pay me at least $80,000 a year or more. He put that in the email to me. Then a couple of weeks later, we met in person in Chicago, and then we discussed it further. And then he put in some additional things for me to do for him personally on his own behalf. And then I'll pay you $120,000. Okay. So that was our agreement. So we hashed all that out. And, we have an original email where he asked me to come. And at the beginning, I'll pay you $80,000 or more. And then, as I said, then we had an oral agreement after that. She says in this affidavit, I was at that meeting with Posner and Vukadinovich, and they never talked about his salary and all of the things that went along with it. And then she said, this is real important. And after she talked about, they never had any discussion about the salary and how he was going to be paid and all that kind of stuff. Then she said, I am certain that he would have discussed it, or at a minimum, disclosed it to me due to my involvement with the Posner Center and due to defendants' trust and admiration of my work. He would have told me about it because how much he trusted me, the admiration he had for my work, he would have disclosed that to me, okay? Well, guess what? Here's what Posner really thought about her. And I've already filed this, it's in the case, because I responded to her affidavit. And I filed a motion for an evidentiary hearing. I want the judge to allow me to put her on the witness stand in that federal courtroom so I can question her about this affidavit, because she lied a lot in this affidavit. She told a lot of lies. She made a lot of conclusory statements that you can't even put on an affidavit. I've already addressed that in the court filing, and I asked for a hearing. But this Martin so far, and it's been a while now since I asked for this, he's quiet about it. So I'm going to have to be addressing that here pretty soon. Doesn't sound like he wants to let me put her on the stand so I can show the lies. But remember now how she talked about, Posner would have told me because of all the admiration that he had for me. Here's what he really felt about her, okay? And I'm going to read it right off of an email that Posner sent me, okay? I'm going to read it verbatim. Here's what he said. Brian, now we were talking about an issue, something was going on in the case with a person that was a client in the case. He says to me, Brian, do you have any idea what she's doing? I don't. She sent us 2 blue pages of revisions of the petition for cert, plus a fine print draft revision of the entire petition in 23 pages. She wants the 3 of us to get together and do what? She doesn't write intelligible English, and I think with her suggested changes, the probability of the Supreme Court's granting cert falls to 0. She just talked about, oh, he's got all that trust in my work. He said, she doesn't know what she's talking about. And then he says in the email, he says, and to think, I appointed her regional director for Cook County with an exclamation mark. And she stated under oath, oh, Posner had so much admiration for me and my work, he would have disclosed all of this to me. He's telling me she's a joke. So I filed this. It's in the case, and I asked for a hearing. I want the judge to allow me to put Sakina Carbide on the stand so the truth can come out. But see, so your audience understands, they win cases because they don't want to let the truth come out. So I'm waiting for Martin now, yes or no. I filed a motion. Is he going to let me put her on the stand or not? If he lets me put her on the stand, I get an opportunity to show the court how she lied under oath on the witness stand. If he doesn't let me put her on the stand, that's quite obvious why that would be. But we're not going to let Vukadinovich get the lies out of her on the record in court. That's what that's all about. That's what happens in these court cases. This is important because just so the audience understands the process of how things work. So we had a hearing on December 14th, 2023, just not too long ago, a few months ago. Now, it was a different magistrate because the other one has now been elevated to the 7th Circuit. His name was Kolar was his name. It wasn't this same guy we got now. So he had a hearing. So we had this hearing, and we're getting towards the end of the hearing, and he's given Ellis pretty much everything he wants, and usually at a hearing, both sides get to talk. So this particular hearing, he's doing all the talking, and then half hour goes by. Then he says, well, you know what? We're a half hour in here now, and I'm going to have to adjourn the hearing here because I got another matter I have to attend to. I said, no, wait a minute. What kind of a hearing is this? I haven't gotten to speak my piece here about anything yet here. All you're doing is doing whatever this guy wants. So I said to him, I said, well, I didn't know this was only going to be a half hour hearing. You never told us. A lot of times they'll tell you ahead of time in the order, we'll have a hearing. It's going to be for 1 hour or whatever. They'll tell you that ahead of time. So then he just blanks out, just a minute. Oh, we're done now. We got about a minute here, and then so he adjourned. So I said, no, wait a minute here. Hang on a second. There's something I got to bring up here to you. Okay. So Justin Ellis, the New York lawyer that we've been talking about, he had filed an affidavit. He titled it Declaration of Justin M. Ellis in support of phased discovery. Now, what's happening here is, I don't think anybody's really ever heard of this. Usually in the case, both sides get to conduct discovery in the case. You get to do, get documents, take depositions, both sides do. In this particular case, I don't know, only Posner gets to do discovery. He gets to do discovery on things that could help him get the case dismissed. I don't get to do discovery on the claims in the case. I don't get to discover any evidence, okay? He's calling it phased discovery. Only if you're able to prevail again. See, I had to wait 13 months. There was a motion to dismiss the case. They lost that motion. It took 13 months for a ruling. Nobody could get discovery at all. So I waited it out. I win the ruling, okay? Should get discovery now. Then right away, Ellis comes in. Oh, we're going to file another thing to get the case dismissed. And this Kolar is buying into all of it. So then we have this hearing, and he immediately makes it, oh, we're going to do bifurcated discovery. And well, guess what? Other judges in this circuit said, no, in this division, we do not do bifurcated discovery. That's the precedent in this particular division, but they don't want to follow it. Martin doesn't want to follow it, nor did Kolar want to follow it. So it's an issue. It's in the case right now. I pointed that out. You're not following precedent. You're giving Posner, an influential former federal court of appeals judge, and these lawyers what they want here, and you're doing it without following this division's precedent. So then what happened was Ellis files this affidavit under penalty of perjury, declaration of Justin M. Ellis in support of phase discovery. And here's what he said. I'm going to read this verbatim out of his affidavit. Quote, a search of the Gmail account shows that plaintiff last sent an email to defendant on May 21, 2019. Now, people might think, well, what's the significance of that? It's very significant because they're trying to get the case. They want to bring an argument that the case should be dismissed on statute of limitations grounds. Too much time has went by the time that I asked for the payment for my services as to when I filed the case, okay? Problem they have is he got caught red-handed in his own lie, okay? So he signs that affidavit, he files it in court under penalty of perjury that the last email that I sent was on May 21st, 2019. And then he put some other stuff that in there as well with it. So then I said to the judge, that was a lie. I said, I want to submit some evidence to you to show you that that was a lie. And the judge said, no, while we're done, I said, I told him, I said, I have an email here that I sent to Posner on November 11th, 2020. So he said May 19th, and I was asking him for my payment for my services in 2020, which puts me within the statute of limitations. You follow me so far with the significance? Oh, he didn't even ask for payment. Statute of limitations is up now. 2019 was the last email he sent. That was a lie. So I asked the magistrate then, his name was Kolar then, I want you to take this under judicial notice. Okay, there's a rule where you can put things in judicial notice. Judge looks at it. Okay, I take judicial notice. Now it's a fact. And he wouldn't do it. He said, we're done. He adjourns the hearing. I get on the elevator. I'm almost to the door. I'm literally probably 10 steps away from walking out of the courthouse. And here comes the marshals. The marshal comes to me. Hey, the judge wants everybody back in the courtroom. So I'm thinking, I don't know what this is all about. So we go back up there. So he comes out and he says, well, I've had a chance to read the email in chambers, and it appears that the email does substantiate the plaintiff's position on statute of limitations. So then he said, I'm going to admit it now into evidence. So it took that. So he admits it into evidence. First time around, we're done, didn't even want to, and then he went back there and he read it. He said, oh boy, I messed up because this is very significant. I blew him off and that was a mistake. So he called us back in. I've never heard of that. Hearing's over and then they call you right back in there. I've never heard of that happening. See, he knew he messed up. So then right away, Ellis says, oh, he never gave that to me. Vukadinovich never provided that to me. This is the first time, that he's brought this up to me, and all of that. Okay. And then the magistrate says to me, well, did you provide that to their lawyers ahead of time before the hearing? And I said, no. I said, we're not in discovery. I don't have to provide any information to them. I just gave it to them. I want this to be a motion for judicial notice. All I have to do is present it at the time that I submit my motion for judicial notice. So Ellis now Oh, how do I know it's even authentic? How do I know that's really even a true legitimate copy? I want an electronic copy. And I'm thinking to myself, do you really think that this is not an authentic? Come on. And now, Vukadinovich won't give us an electronic copy and all of this and all of that. You know what? We're not in discovery. You're not giving me any information. I don't have to give you any, and then he said that I ambushed them. He actually stated that I ambushed them. If I could just have another couple of minutes here. And here's what Ellis said on court filings regarding that issue, that affidavit or the email after he lied. He said, giving defendant and the court no notice and no chance to prepare for the upcoming hearing. I didn't give them that. You know what? I don't have to give corrupt lawyers advance notice of their own crimes. People that rob banks don't call the bank ahead of time and say, hey, guess what? I'm coming in a half hour. They don't do that. I don't have to give him advance notice of his crime. And I use the word crime because what he did was a federal crime. When you lie on an affidavit in federal court, there's a federal statute and it's punishable by fine and or imprisonment of up to 5 years. And I cited that. I asked the court to sanction him to refer it to the U.S. Attorney's Office. It was a crime. Okay. And then he said, defendant has not yet been able to determine whether the purported email is genuine. Oh, how do we know it's not a fake email? Yeah, I'm going to walk into court with a fake email. Yeah, right. The court should not consider the purported email for purposes of bifurcation because plaintiff has used it to improperly ambush defendant and the court. And I brought the evidence in of his lie, and he's calling it now that I ambushed him. Can you believe it? Plaintiff chose to submit it by surprise at the December 14 hearing. It was a surprise. Well, you know what? Then don't perjure yourself on an affidavit if you're going to worry about getting ambushed or surprised at a hearing. Worse, plaintiff submitted the purported email only in paper format and has so far stonewalled defendant and has so far stonewalled defendant's attempt to get more information about it. I have stonewalled him, he said. The court should not permit plaintiff to gain an advantage through surprise tactics. But now listen to this one now, after all of that nonsense. But even if the purported email is authentic, it changes nothing about the need for phase discovery. Come on. Oh, we got ambushed with it. How do we even know it's, you surprised us with it? And you know what? Even if it is authentic, it shouldn't matter. Well, then why are you crying about it so much? Why are you whining and crying like a baby? And that's exactly what Justin Ellis is doing in this case. He's whining and crying like a baby in this case because he knows he can't beat me at a trial, and he's doing everything he can to avoid a trial with me because he knows I'm going to beat him. I'm going to win this case. I'm going to show that his client, Richard A. Posner, breached the contract and tried to get slave labor out of me. I did all that work for him, and he doesn't want to pay it. And now he's basically arguing for slave labor in the case. That's what happens in these cases. And I can see, particularly this magistrate, Martin, I can see the direction that this thing is kind of headed in how he's kind of going about things with these rulings here. So I can only do what I can do. I can only address things legally. I've already reported it to the chief judge. And as things go forward, that's what I will continue to do. And, if I have to appeal it, I will. And, we'll see what happens in the end. So the moral of the story, don't let yourself get run over, because I had to deal with a lot of stuff in the first trial. I got through it. I got to deal with a lot of stuff here, and I will address this stuff as well. So when the people that are watching this, when you're involved in the case, stand up, be heard, do your homework now. Don't wing it. And maybe sometime down the road, maybe we can actually have maybe a show where we're actually talking about, evidence, how to get evidence in and how to, respond, because they're always objecting to things and this and that. And there's a whole lot of things involved. You just even forget the trial, just trying to get to a trial. There's a whole lot of things involved that people have, I mean, for give you one short example. This one lady that I talked to about her case, I got screwed. The judge dismissed my case on summary judgment, something we were talking about earlier. Dismissed my case, and she sent me the papers for me to look at and so forth. So first thing I say is, let me see the ruling, what the judge said, why the case was being dismissed. So the judge dismissed it on a technicality. On a summary judgment, when you respond, you have to file what's called a statement of genuine issues of material fact. It's a complicated thing, but you have to do it. And she didn't. Okay. And you file your evidence, you put in exhibits, but you have to file that particular thing. It's called the statement of genuine issues of material fact. And she didn't file that. And the judge said, you lose. You didn't comply with the requirements of the rule. So I don't know, he might have ruled against her anyway, who knows? But he said, you lose because you did not comply with the rule. And she was mad. And I told her, I said, I sympathize with you, but you did not follow. You have to do, because they're already looking for a reason to rule against you. You're pro se. And that's what they look for when you're pro se. They'll mess up when they're filing stuff. Let's wait for the mess up. And then they jump on that technicality. That's just kind of like something that people keep in mind before you do stuff, file stuff. Get into if you're in state court, get familiar with the state rules of civil procedure in your state. Every state has their own rules. If you're in federal court, it's uniform. If you're in federal court, it doesn't matter what state you're in, same rules for everybody. Then you go into the federal rules of civil procedure. Those will tell you the governing rules for whatever you're doing in the case as you move along. And also, you need to be familiar with the federal rules of evidence. Same thing in state courts, the state court rules of evidence, because you'll lose out on technicalities. That's what the audience, the pro ses, need to understand and do some homework on if they're going to move forward in their cases, or they're probably going to lose.
Wow. Oh my gosh, your story is incredible. It's amazing to see everything you've overcome and all the research that you did and your confidence, because like you said, a lot of people go in and they're sort of submissive and they're controlled by the environment instead of going in and realizing that they have the potential to put their foot down and assert their own control over the situation and, speak up. Because you really only get so many chances to do this. If you don't take those steps when you're granted the opportunity, you don't get it again, and they use that against you. So I think you're so courageous. You're helping, speak on behalf of a lot of people who don't have a voice. And what I love about this is, like I said, it gives us an insight into some real life experiences in like a real life case where we can see what goes wrong, what goes right, how to navigate it a little bit, and how it can work to your advantage if you speak up instead of holding your tongue. So I love what you're doing, Brian. And I think you're a hero, for being able to do this. And it's going to help so many people. I think your work is going to, be recognized now. And I think throughout time, people are going to be studying this case and seeing what they can learn from it, and realizing how they can self-represent and not have to necessarily rely on the same methods that we're told we have to with getting a lawyer, being appointed a lawyer, so I really love what you're doing and I love this work. And like I said, I think we could definitely do a whole series of episodes on this. I know that we just sort of touched the iceberg, but I wanted to give you a chance too to talk about your work didn't stop there. You have 2 books, you're on social media. I want you to talk about that and let people know how they can support you.
If if people would go to my website, I think you're going to put that up, I believe. If people go to my website, they will also see writings that I've done, things that I've written, I've done a lot of blogs, and under media, they can see interviews I've done, writings that I've done, blogs where I'm talking about issues and I'm talking about courts and judges and so forth. And if they read some of my actual writings that I've done, you can there's some things you can pick up on there that might actually be helpful even in the cases that they're doing. For example, something that people may not know about is you're actually entitled under the U.S. Constitution or under a congressional act. It's the Judiciary Act of 1789, where Congress gave people the right to represent themselves in court. Okay. So if anybody's getting a bad mouth by a judge for representing themselves, if they want to write down the Judiciary Act of 1789, what I would say to the judge is, I would politely say, Judge, I'm sorry, I don't know if you know this or not, but under the Judiciary Act of 1789, Congress has given me the right to represent myself. Therefore, you have to respect my right to represent myself. It's a congressional act. And see, judges, I don't even know, maybe a lot of them don't even know it. I don't know, but they need to know it. And, I would certainly, if a judge came down on me, hey, I don't want you in my courtroom. What do you mean you don't want me in your courtroom without a lawyer? You don't have any choice, because by Congress, I have a congressional act. I have a right to be in here representing myself. So a lot of these things you can pick up just by reading some of the under media, the writings I've done, and now under my blogs, I've written stuff, about judges and even political things with courts and so forth. I've written about the Senate Judiciary Committee, and the one you have here right now, judges shouldn't be riding shotgun with rogue police. That one's about how judges, there's been a lot of issues in the country with police brutalities and harassments and so forth. And the research I've done, and I've been through some of that myself as well, which kind of got me started with this whole thing. And I'm talking about how judges, there's a thing called qualified immunity that a lot of people hear about with police. They get beat up by police, and then when they try to sue, the judge lets them off. They have qualified immunity, they call it. And it's a big problem. And it's not even a law. A lot of people think it's a law, and it's not. It's something that was conjured up by the Supreme Court a long time ago. Qualified immunity for police, so everybody understands, is not a law. It's something that the Supreme Court conjured up. So it's not. Congress can take that away. They can just completely do that, take that away. There's a lot of things Congress could do that I could talk about in terms of things that judges are doing with these lifetime appointments and their pensions. People say, well, what can you do? They're on, they have lifetime appointments. There's a lot of things you can do. First of all, judges, by the way, federal judges can be impeached, by the way. Okay. Hasn't happened very often. It's only happened once or twice in the history of the country, but it has happened and it is there. But you need 2/3 of the Senate to vote to convict them, and it's pretty much almost impossible to do these days. But there's other things they can do. Federal judges have pension for life. Whatever their most federal judges are making somewhere between $250,000 and $250,000 a year, depending on where they're district judge, appellate judge, Supreme Court. And a lot of people don't realize this, but when a federal judge retires, let's say that judge was making $220,000 a year, okay, and most of them are in that range, okay. When he retires, or she, okay, that's their pension amount. They get $220,000 a year for life. Now, who gets that kind of a pension? Whatever their salary was that year they retired, and it's somewhere in that range, that's what they get. And they got that because Congress gave them that. Now, Congress can also take that away. if we want to put the hammer down, if judges are misbehaving, that's a tool that could be used against them. They can take those pensions away from them. That's not in the Constitution. Congress giveth and Congress can taketh. Okay, they gave it to them. They can take it away. I'm just throwing that out there as one example. If everybody in the country will call their senators and their representatives, hey, we don't like what's going on in the judiciary. We don't think these judges should be getting those kinds of pensions. You can take them away. We want them to be put in check, and we want you to take those pensions away from them. They could do that. So there's things that could be done. They just don't want to do it. You know why they don't want to do it? Because people don't complain about it. That's my job and your job. We're going to educate the people about this so we can get a movement going in the country and get the judiciary. We want the judiciary to be what it's supposed to be, fair and just, which it is not these days. And we need to change that.
Amen to that. And talk about your books and where people can find those too.
My first book, Motion for Justice, I Rest My Case, published that in 2018, and then about a year later or so, they came out with the paperback on it. Always the paperbacks are a lot cheaper, and I always want them to, I'm not doing this to make a ton of money. I just want people to understand, they can read and they can see what I went through, how I handle things. Like in that book there, it'll tell the story about how I became a self-represented litigant. I was going to talk about it in our interview, but you can only talk about so much, and the lawyer was just taking my money, and I found out he wasn't doing things that under the law would have benefited me. And when I confronted him with it, he didn't like hearing it. Just to make a long story short here, 10 seconds here. So I confronted him. I did my research. I went into his office and I said, hey, listen, is this what the law says? Yes or no? Why do I have all these charges that I have to deal with when the law says they should be dismissed by now? Yes or no? Am I right about that? Well, it's not that easy, he said. I said, I didn't ask you if it was easy. I asked you if that's what the law said. And if that's what the law said, I want to know how come you have not addressed that in court. So he said, well, it's not that easy, and that's how it is. I said, well, I'm going to tell you what. If you don't file motions to dismiss these charges against me, that's another story, about how all this stuff started. And it's all in there. You can see the handcuffs on the cover there. Okay. And then I said, then I will file the motions myself to dismiss those cases. There were several of them. And his exact words to me were, you're not filing a damn thing. Okay. And I said to him, you're fired. I fired him on the spot. And I went home. My brother said, well, how did it go? What happened? I said, hey, I fired him. And I told him what happened, what I just said here. And I said, I'm going to represent myself. So I got on my Smith Corona typewriter. Back in those days, it wasn't like this with the computers and stuff. We did typewriter stuff back then. I had my old typewriter from college, actually, Smith Corona typewriter. I typed each one individually. I took it to court, filed it. And guess what? Every one of those cases, the judge dismissed them all, something that the lawyer would not do. And when I confronted him with it, he still, that's the games the lawyers play when they're taking money from their clients. I paid you money. I'm asking you if this is what the law says. I know that's what the law says because I read the law. I did the research. And he couldn't make himself say yes. And then when I demanded that he file the motions in the case, he wouldn't do it, and I fired him. And from that point on, I represented myself in everything. And I bought a law dictionary and started learning the terms. I started going to trials. I started looking at court papers. I just, I self-learned it, myself, and so forth, and got to the point in that federal trial. I was the one that did a lot of stuff in between as well. And so that's how it works. So all of that's in there, in that particular book. And then in the one that I just wrote, Rogues in Black Robes. Oh, by the way, in my previous book, I had some really neat quotes in there from, remember the O.J. Simpson trial? One of his lawyers, Robert Shapiro, was one of his lead lawyers. He gave me a quote, a real nice quote that he allowed me to put on the book. And also a movie came out a long time ago. was called Presumed Innocent. Harrison Ford was the main person in it. Scott Turow wrote it. He gave me a nice quote. It's on the cover. And on this book here, I don't know if people will remember or not. The forward was written by Samantha Geimer, and I don't know if people remember the Roman Polanski case back in the day, a long, long time ago. It was an international case. He was a big movie producer in Hollywood, one of the top ones. And he raped her. She was 13 years old. He raped her at Jack Nicholson's house, the actor. And he got convicted, and then he fled the country. He went to somewhere in Switzerland, I think it was, to avoid the jail time and so forth. It was an international story. If you Google it, you'll see all. So she wrote the foreword to this book because of her bad experience in court with things, dealing with the stuff with that. So she wrote, but this one is about case fixing, because this judge that I've been talking about, Posner, him and I became friends after he hired me to work for him. We became good friends, and I was working for him. I was coming up and we were having lunches. He was inviting me up there, and he publicly proclaimed, when he retired from the judiciary after 36 years, he publicly proclaimed that the pro se's are getting a raw deal in the courts. Judges are, his words, not mine. The judges at the Seventh Circuit considered pro se's, now his words, not mine, considered the pro se's as trash. Those were his words. The judges considered pro se litigants as trash. So he quit, he retired, he started the Pro Se Center, Justice for Pro Se's. He named me as executive director, and then he disclosed to me that he was actually himself involved in a case-fixing case of mine. And I reported it to the Seventh Circuit. I went through the judicial steps to report it. So it's all in here. It's in the book here. And now normally, and everything I'm saying here is in the book. And normally now, when you do an investigation, I had to file an affidavit. I filed it with the Seventh Circuit in Chicago. I told them what Posner confessed to me about. There was another judge who didn't like me. He was a guy from Indiana. He went to him and approached him. We got to make sure Vukadinovich doesn't win. Okay. There was some bad history with me and that particular judge in the past. Oh, hey, listen, Posner, you got that case with Vukadinovich. I want to make sure now. And Posner said, hey, sometimes we do favors for judges, blah, blah, blah. I shouldn't have done it, all of that stuff. I put it all in the affidavit. I gave it to the Seventh Circuit. So then the Seventh Circuit, this is another problem we have in the country. So when you file a judicial misconduct complaint, it's all done in secret, and it's all the judges deciding. A lot of times they're their own friends, that are making the decisions about it, and they throw. I did a lot of research. I've got the research in the book. Almost 100%, whenever citizens across the country file the complaints, almost 100% they throw them out. I put the statistics in there. So then in this case here, her name, the chief judge, they have a so-called judicial council. She dismisses the complaint, as they do in almost 100% of the cases. And she said, well, it was a long time ago and people died. Nobody died at this time. Nobody died. The case fixer in chief, Caney, he was still alive. Posner, he's still alive today. He was just off of the judiciary. They could have called him. They could have called him on the telephone and said, hey, listen, Vukadinovich filed this affidavit, and here's what he said you told him, and now he's got a complaint that he filed with us here at the Seventh Circuit. Did you tell him that? Now, normally that's what you would do in any type of an investigation. You would want to get did that happen? So, well, they didn't contact him to ask him that question. Now, I think the answer to that question is real simple. Why would they not want to contact him and get an answer from him? The answer is real obvious. If we contact him and he confirms that we have case fixing going on here, we got a big problem. So we don't want to ask him, because then it's on the record. Then the proof is there, and then everybody knows that we have a corrupt circuit here at the Seventh Circuit. That's how the judiciary operates. I've got a lot of information in there about that topic. So I use my, that situation, that happened with me as the example. I've got other stuff in there about how people are turning in judges, and judges are and I got stuff in there about even Merrick Garland, the Attorney General of the United States. He was a judge before he was Attorney General, and he was an appellate judge, a chief judge of an appellate circuit, and there was a complaint made. I think it was in Texas, and he was overseeing it, and then he made a rule that it had to be done in secret, and only one side of the case got to ask questions and so forth, to protect the judge that the complaint was made against. That was Merrick Garland that did that, and that's in this book. I've got all that stuff in there. So if people read it, they can get a pretty good idea across the board how the judiciary operates, how the mechanisms are set up to screw people over and to protect one another and to protect the corruption that's going on within the judiciary. And when I say corruption, I don't necessarily mean money passing. Corruption, I mean, okay, we're going to decide this way just because we don't want this particular person to win. We want the government to win. That's all corruption. It's all, it's all in the same category. Case fixing, for whatever reason, it's corrupt. And it's going on all over the country. And I've got a lot of information about it in there. And if you'll have me back, we can do another show, an educational type show, and if people want to tune in, and if people want to give some in advance a little bit of ideas about what they'd like to hear, what we want to talk about, hey, I'm open to, we can discuss anything.
Absolutely. And I encourage people to please go purchase these books. We always think that stuff can't happen to us. And what I'm finding is this is so common in all aspects of court, whether it's family court, criminal court, state court, whatever it is. It's always the people that think that it could never happen to them that it does. And more likely than not, even if it never happens to you, the chances of you meeting somebody that these things can happen to is very high. So I think just for everybody, we need to relearn how our world works. And that starts with sort of re-educating ourselves on how the courts actually work versus how movies and television have conditioned us to believe that they work. So I think this stuff's important. I encourage everybody. They're on Amazon. I'm going to have the links in the show notes for you guys. Make it super easy. No matter what platform you're on, you'll just go in the show notes and it'll light up like a hyperlink. You'll just click it and it'll divert you right to Amazon where you can purchase these. So I really encourage you guys to. These would also make great gifts if you know somebody who is going through this. Give it to them as a gift or tell them about it. These things can save lives, literally. Having resources like what Brian's provided for us can literally save a life. And this, I think these lessons can apply to all aspects of court. Even though Brian's court case is a specific aspect of court, I think the lessons that he's learned can transpose to all aspects of court, no matter what you're going through. So I really encourage you guys to go support him and get these books. And Brian, where are you on social media also, so people can follow you and keep in touch with you and or reach out?
Yeah, well, a great place. I'm on Twitter, and I got to tell you, there's all kinds of people on Twitter that are involved with court cases. And I mean, I'm busy all day long. There's people putting posts up and sending messages, all kinds of people on Twitter with court cases. So I'm at that symbol at motion for, yeah, the number 4, motion for justice is my name on Twitter. So, if you're on Twitter, go on there and you'll see a lot of stuff. I'll have stuff on there. You'll see stuff from, other people are on there. I know you're on there too. Actually, I saw your posting on here about our interview. You did a great job with that. So Twitter is a great place. And I'm also on, I have a Facebook page. And then I do mostly on Twitter, though, much more than on Facebook. And then that one's, let's see. I guess that one is, that one's more complicated to get on Twitter. I don't know what you have the link up there though, right?
I will. Yep. Looks like it's just underneath your name. So people can just type your
Well,
name in Facebook and it should populate.
'cause Twitter's easy. That one's Motion for Justice. But I've got some stuff, but most of my stuff is on Twitter, although I do have a little bit there on Facebook as well. So I hear from people on Facebook too. So either one of them's fine. And then my website, I've got, my website, I've got on the bottom over there, you can see the number of people that are going on there. I think it's over 152,000 right now. Yeah,
Oh
it's
yeah, you're right. Look at that.
yeah, pretty soon it's going to be 153,000 pretty soon. So a lot of people are going on there. I haven't done any blogs in quite a while. Whenever I was writing a blog, I'd have 1,000 that same day. They're writing the blogs. But I've been real busy with a lot of stuff. I haven't been able to do blogs lately. So I've got quite a bit of stuff on there too. I need to update it more. I've got a lot of stuff that I've done since then. I did a speaking engagement not too long ago in Southern Indiana. I was talking about judicial corruption and so forth. So I haven't had a chance to put that on there yet either. So I've been doing quite a bit of stuff. I don't have it all on there yet. And so hopefully I'll be able to get stuff on there. But also people need to watch, what you're doing here as well, because I have to say, when we first got acquainted with this, I went back and I looked at, your stuff and I saw, several of your interviews and so forth. And I looked also on Twitter and saw things on there. So, you're doing your part on your end for sure as well. And I know you focus in a lot on the trafficking issues that are going on with sex trafficking and, human trafficking and the family court system and so forth. And I know that is a big problem in the country because I've gotten enlightened to some of that stuff myself as well. So I've been doing a little bit of research on that. So you're doing a great job with there because that's really something that, as I earlier talked, they had the Cash for Kids thing where the judge was taking kickbacks for whatever the juvenile was doing. He would just put them in that center, and then the owner of the center was passing money back to the judge so he could fill up the rooms at his center. And there's a lot of stuff going on in the family court system that needs to be investigated. There's a
Man,
lot of money going back and forth between lawyers and judges for sure.
yes, absolutely. And Brian, your work is really monumental. It's awesome to see you pioneering this type of work and writing literature on it. This is a topic you don't see covered very much in nonfiction or fiction, and I think it's going to grow in popularity as time goes on. As more people wake up to this corruption happening, they're going to need outlets to learn about it. So I really appreciate all the work that you've done. You could have easily just stayed quiet about all this. You could have kept it to yourself. I love how much you've learned and how you felt a calling to pay it forward and share with other people. So hopefully we can prevent or even help people going through it, but more so I hope we can prevent people from even getting in the situation to begin with to where they could be taken advantage of. So I just want to thank you on behalf of, everybody, the survivor community and everybody else outside of it. Just thank you for, standing up for victims. Thank you for educating on all the years of experience that you have in and out of court and for sharing what you've learned, because I know it's going to be really, really helpful for people who feel helpless, who feel alone, who can't find information on it. It's really great to see you out here using your voice and creating resources for us to learn from you. So thank you from the bottom of my heart for all your hard work.
You're very welcome, Emma, and thank you for having me on. I really appreciate that, and we're going to do good stuff going forward here for sure.
I agree, and I would love to have you on again. I know we just scratched the tip of the iceberg. I really appreciate you sharing your testimony. It's an absolutely harrowing testimony, but at the same time, it's awesome to see how your courageousness has essentially paid off for you. And I ask everybody listening to please pray for Brian, pray over his case as he's moving forward because he's obviously still his case is still active. So pray that things continue to go up and up and up, and that he can keep writing books and setting an example for us to follow in the future, for people who want to be self-represented, and to help create ways and avenues for that. So let's all say a prayer over Brian and over his case and over his progress and every other project that he's going to bring to life. And please go support him, grab his books, Go follow him on social media. Twitter has been a really cool place. It's great connecting with people on there, and there's a whole community on there. If you guys aren't on Twitter, I definitely encourage you guys to get on there. And Brian, is there anything else that you wanted to cover today or say before we start closing up?
No, other than, this was a great show. You do a great show. And I'm just from the bottom of my heart, thank you for inviting me to, come on here like you did, because, like you said, everything we talked about is very important. And by the way, not just for pro se's, it's good for people, even when they have lawyers, to understand how things work. As I, mentioned just a little bit, we were talking earlier, you're paying those lawyers, but sometimes they're not earning their money, so to speak. So sometimes it's good for you also to know how the process works, so you can ask questions. You should be able to ask questions of your lawyer and getting your money's worth when you're paying these lawyers, and that's not always happening either. So it's a good thing for us to talk about these things, even for the people that are represented as well.
100%. And that's why I wanted to bring you on here, because we need to understand all aspects of this. It can apply to anybody. I personally have a fascination in this just because I've met so many people who have gone through a really horrible court proceeding, and the outcome was not in their favor, even though it should have been, and they always say, I wish I would have known then what I know now. And so you're helping create a shortcut for that, to where we can be a little bit ahead of the game. We can start learning how these systems actually work. We can learn how to navigate them. And like you said, even if we have a great lawyer, we still want open lines of communication. We want to understand what they do. We want a good back and forth. We want to make sure that these relationships are in favor of a positive outcome that's reliant on truth and actual justice. And like you said, understanding what questions to ask, understanding how to sort of vet people, having confidence going into the courtroom, regardless of lawyer or not. We want to just be empowered with the information, so we don't have any curveballs thrown at us and saying, oh my gosh, I thought it was going to go one way and it didn't, So this is all really great, Brian, and I look forward to having you back on again. And everybody listening, I really appreciate you guys sticking in and listening with us. I hope that you guys got as much value out of this as I did, and I encourage you guys to go share this episode, especially, like I said, if you know people going through this, which I'm sure a lot of you do, go share it with them. This is another great resource, and it'll lead people to find Brian's books and his website. And like I said, maybe we can prevent some people from going through really hard things, like how we've heard on this podcast, and even how Brian's case started, where he was really thrown off. So I appreciate you guys listening. I'll have Brian's books in the show notes as well. Go connect with him, go support him. Thank you guys so much. God bless you, and we will see you next time.